Next, item 2E, we have a presentation on the California Voting Rights Act by Jonathan Salt, representing Fagan, Friedman, and Fullfrost.
Just give us a second, we'll get it up. I did see it up at one point, not too long ago, on this one.
Hang on just a second, and because your mic's not on yet, but it's going to be
There you
very
go.
soon.
Hear me?
You're on now. It's the first one.
This one?
Okay.
Good evening. My name is Jonathan Salt. I'm an attorney with Fagan, Friedman, and Fullfrost. I'm here tonight to discuss the California Voting Rights Act, or the CVRA. What is the California Voting Rights Act? Well, it took effect about 15 years ago, and it prohibits the use of at-large elections if those elections impair the ability of members of protected classes to influence the outcome of an election or elect candidates of their choice. An at-large election is how the district currently votes and voted a few weeks ago. It means that candidates can come from anywhere that they reside within the district boundaries, and all members of the community vote on such a board member. The law essentially says that if that system prohibits the use, members of protected classes from influencing the election, it's illegal even if there's no intent. So unlike the Federal Voting Rights Act, the California Voting Rights Act is far more broad. It's much easier for a plaintiff to bring a claim against a government entity, and proof of intent that the district is trying to discriminate or a city is trying to discriminate is not required. The key term of art is racially polarized voting, and so there'll be regression charts that show that, for example, if the Latino population, based on surnames, tends to vote a certain way, but that candidate, no matter what race they are, isn't elected, that is evidence of racially polarized voting, even if there's no intent on the district's part. Key issue with the CVRA, one of the reasons you're seeing this all over the state, is that a prevailing plaintiff is entitled to attorney's fees and experts' fees, but if a public entity wins and successfully defends itself, it's entitled to nothing. To date, no public entity has ever successfully defended a lawsuit alleging a CVRA violation. But those cities and districts that have fought this kind of a claim have spent millions of dollars in their own defense. Specifically, the city of Palmdale in 2013 ended up losing at trial. They appealed and ultimately settled for $4.5 million plus their own legal fees, which is estimated to combine to total around $7 million. And last week, the city of Santa Monica, for the last few years, has been fighting a claim, lost at trial, and it's estimated they've spent $5 million in their own defense, and it's estimated that they'll owe approximately $10 million to the other side, although there's evidence that they may appeal. Unlike Palmdale, which was a majority-minority community, Santa Monica is only 13% Latino by eligible voters, and there the court still found that there was evidence of racially polarized voting. The only safe harbor from a CVRA claim is to transition to a bride trustee area election system. That means the district will be divided into 5 equal population areas based on the most recent census, and that board members will be elected from the trustee area that they live in by only members of that community. AB 350 passed a few years ago, and that's why you're seeing this push around the state. It attached a reimbursement amount for any plaintiff who sends a demand letter to a public entity. They're entitled to up to $30,000 in reimbursement, even if the entity changes in response to that demand letter. And it also creates these very rapid timelines for facilitating this transition. So potential next steps. The first step is to pass a resolution initiating the transition process. This starts a 90-day safe harbor where the district cannot be sued for an alleged violation of the CVRA. Next, within the first 30 days, the district must hold 2 what I call pre-map public hearings. What that means is there are no draft maps, there's no Hypothetical scenarios, it's just community members telling the board what they think the map should look like, or ideas, for example, community A or neighborhood A, neighborhood B should probably be together. Or we think that this street makes a good boundary, and you can separate the other sides of the street. So after those 2 public hearings, the district's demographer will draw draft maps that will be released to the public. In order to draw them, obviously equal population, so there's a small variance of 10% that can be between the districts, but essentially equal population per trustee area. And there are several other factors like communities of interest, compactness, and compliance with the Federal Voting Rights Act. The maps cannot be drawn to favor or discriminate against any incumbent or political candidate. Once the maps are drawn and released, the district will hold 3 more public hearings at board meetings where members of the community can comment on what they like or don't like about the maps or what changes folks would like to see to the maps. At the final public hearing, the district's board will vote on approve one of the map options and submit it to the County Committee on School District Organization, where they'll have another public hearing and ultimately decide to, 1, approve the district's transition, and 2, approve the district's map. The process is supposed to then go to an election where the county committee orders an election for the district's electorate to vote on the transition. However, that is very costly and it takes a lot of time and no longer protects the district in the meantime from a CVRA lawsuit. The Education Code permits school districts to waive this election requirement after the whole process is complete. So after all the 5 public hearings, the map adoption, at that point the district can seek a waiver that says, essentially the district does not have to put it up for a vote afterwards. This saves the district time, money, and uncertainty and reduces the risk of any challenge to the system change. Finally, once the waiver is obtained and the county approves, the district will file the new plan with the county and hold elections in 2020. Importantly, every time there's a new federal census, and there's one coming out in the spring of 2021, the district must make sure that its boundaries still have roughly equal population. So there might be some slight tweaks before the 2022 election. And it's also important to keep in mind that though the district will be potentially divided into trustee areas, that all board members owe a duty to the entire district. It's still one community with the common goals and challenges. Any questions?
John?
Mr. Dunn.
What was the name of the case that you referred to involving Santa Monica?
I think it was Pico Neighborhood Association, and then there was a plaintiff whose name I don't know exactly off the top of my head, but it was Pico Neighborhood versus City of Santa Monica.
Was it Maria
Yes.
L. Loya?
Yes.
Thank you.
Are you prepared to explain what happens to sitting board members and the transition process to the next 2 elections?
Yes. Any current trustee or newly elected trustees, it's explicitly listed in the statutes that your term continues through its expiration. It's not cut short just because the district changes and maybe it's drawn in a way where you might be paired with another trustee as well. So all candidates or all board members serve out their full 4 or remaining 2 years of their term. Depending upon how the maps are drawn or where folks live, sometimes it's not possible to keep everyone in their own trustee area. For example, if your next door neighbor is also a board member, odds are it would be too gerrymandered to split it down that street. So in those scenarios, when one's term is expired, let's say someone whose term expires in 2020 versus someone whose term expires in 2022, if they're in the same area, at the expiration of the 2020 term, that person can't run until 2022 because someone else will be filling that seat. And at that election, there'll probably be an open area that will then have an election in the next board election. So it's going to depend a lot on how the maps look. Sometimes there's more than one open area. We usually encourage that if there's an open area, that should have an election as soon as possible. But essentially, it's just going to be depending on how the maps look. But everyone's term continues through the end.
I know, Pat, last board meeting, there was question from Board Member Phelps in regards to the waiver. I think you covered that a little bit in your presentation, but can you just to reiterate a little bit about what that waiver process does for us as a district and as a community?
Sure. As I mentioned, the district, if the district moves forward, there has to be 5 public hearings in this 90-day period of time. It's very transparent. After the board ultimately adopts a map and sends it to the county holds a public hearing and will hopefully approve the district's transition. At that point, the Ed Code currently says that the county committee will then order the district to have an election for the electorate to essentially approve of what the county and board have already approved of. What the waiver does is at that point eliminate that election requirement so that the transition can be implemented as soon as possible. It saves the time saves time because the election is not going to be for so long and the cost of holding an election.
In the early part of your presentation, you mentioned that a firm or plaintiff filing a demand letter with an organization has the right to collect a, fee, damages, I'm not sure what's the right word to put.
A reimbursement of their costs to write the letter.
A reimbursement of their costs. And so typically you have seen, or the state sees, what amount of money, is there a maximum? How much money do these organizations make by merely sending a demand letter to a board?
The demand letter reimbursement is capped at $30,000. Obviously, it doesn't seem like writing a letter would cost $30,000, although potentially the cost of hiring a demographer to determine if there's racially polarized voting could be a lot of upfront costs for a prospective plaintiff and their attorney's fees to write that letter. We've seen more often than not that the sort of reimbursement request comes in at greater than $30,000, although the district's only obligated to cap that reimbursement check at $30,000 or hopefully less.
Have you seen many different, and you may not know the answer to this, many different plaintiffs and firms issuing the demand letters, or is it a fairly consolidated operation?
While there have been multiple plaintiffs' attorneys or plaintiffs who have issued demand letters, the main sort of plaintiff's attorney around the state is located in Malibu. His name is Kevin Schenkman. He is the plaintiff's attorney who represented the plaintiff against the city of Palmdale, as well as the recent case in the city of Santa Monica.
Mr. Dunn?
I was looking on the internet for a summary of this case. I couldn't find it. When did this decision against Santa Monica take place? When was the summary? When did the judge make the ruling?
The judge made the ruling, I think it was either the first or second week of November, so very recent. I think maybe a tentative was issued around the 8th or 9th, and it became official on around the 11th or 13th or so. I don't remember exactly. I have not seen it. It's only 2 pages, the decision, which is one of the reasons why Santa Monica has so far stated that they plan to appeal.
And you estimate it's going to cost Santa Monica $10 million?
According to the newspaper articles, Mr. Schenkman and his co-counsel have claimed that should the city appeal, their own fees will probably reach around $10 million. It's also estimated that the city has spent about $5 million on their own defense.
And their percentage of Latinos is about 13%, you said?
13% based on eligible voters. I think it's 16% overall, but based on eligible voters, 13%.
When we discuss equal population in our districts, is that voter population or just population in general?
Population in general. So does anyone offhand know the exact number of people in the district or based on the last census? Well,
Who are Latinos?
the entire population.
Roughly 126,000.
Okay. Let's just go with 125. So there'll be approximately 25,000 people per district based on the most recent census. So even though there's probably been growth in certain areas, or maybe some folks have moved away in certain areas, it goes based on the most recent census because that's the most accurate count at the time, and then it changes every 10 years.
So, sorry. So then, will they try and get 25,000 people who are likely minority in one of those areas? Is that how the demographer will work, or?
The maps can't be gerrymandered to try to create that. So if the population of the minorities in this district are equally spread out, it'll be more difficult. But because the maps have to look contiguous, they can't look, have, fingers sliding around, that it wouldn't look right. Actually, a lot of congressional districts look like that, and there have been some issues lately with that too. So they want to be as compact or contiguous as possible. But if there is an area that does have a larger than the district average population of a particular protected class, that would be beneficial, because then that group in that area would have an increased chance of influencing the outcome of an election in that area.
Okay, seeing no other comments or questions, thank you very much.
Thank you.
Appreciate you coming and sharing that information.
Anytime.
Mr. Anderson, can I ask one more question?
Certainly.
How long does the district have to put it before the county Committee on School District Organization? Is there a time limit on that?
The way the statute that forces these new rapid timelines was written, in my opinion, didn't factor in that school districts have to go to their county office of ed for approval. So our position is that if you complete all of your public hearings and then adopt a map within 90 days, you're safe, and then immediately petition to the county. Some counties take longer than others to schedule the public hearing, vote on it, and move forwards. So there isn't a specific timeline of when the county needs to approve, but if the district completes the process within the 90 days and submits it to the county, the district should be safe.
So the district can go ahead with elections then, even if the county hasn't approved it? Like, say we were doing this process before the current election came up. If the county had not heard it, we still would have gone under the new system for this election?
Probably not, because the county needs to, in theory, order an election of the transition, which the district would have to seek a waiver for to prevent. And it takes about 3 months to get onto the state's agenda at the CDE meeting. So unless the district started the transition in, say, March, it would have been very difficult to complete the transition for this November.
I believe Ventura's already converted to this system, but it hasn't gone before the county yet. So I didn't know how that works. That's why I'm asking.
Okay,
Thank
I
you.
think we're ready to move on then.